Special circumstances are unique facts about your family that may change the way the law treats you. Some examples include grandparents, military service, and domestic violence. Third-party custody. Third-party custody is when custody is awarded to someone who is not the child's birth or legal parent. A third-party custodian can be a relative of the child or someone who is not related to the child but who has a significant family-like bond. Getting third-party custody. By default, the court believes that birth parents are fit to be parents. If you are seeking to become a third-party custodian of a child, you must prove that it is not in the child's best interest to live with their birth parents. You do this by providing evidence, including the birth parents are unfit, unsuitable, or unable to have custody of the child, or the well-being of the child requires removal from the birth parent's custody. Some examples may include abuse, neglect, or abandonment of the child. It is in the child's best interest that you are awarded custody of the child. It is important to show that you are able to provide full-time care for the child and provide a stable, safe, and nurturing home. Specific situations that interfere with the birth parents providing proper care for the child. Some examples include the birth parents have not been the child's primary caretaker for most of the child's life, has not provided safe and stable housing for the child, or has not shown regular positive involvement in the child's life. What rights do grandparents have to see their grandchildren in Missouri? There are 3 circumstances in which a grandparent can ask the court for visitation rights. 1, if the parents of the child have filed for divorce. 2, one parent has died and the living parent does not allow the grandparent to visit the child. Or 3, the child has lived with the grandparents for 6 of the last 24 months. A grandparent can ask a court to grant them visitation if they have been unreasonably denied visitation for 60 days. However, if the child's parents are married and living together with the child, a grandparent has no legal ability to obtain visitation rights. Under any circumstance, the court will only grant visitation rights to the grandparent if it feels visitation is in the best interest of the child. If my child gets divorced, do I have a right to see my grandchildren? If a grandparent is denied visitation after divorce, they can submit a written request to the court. The court then can choose to order mediation with the person who has custody or the right to choose who can visit the child. If the court orders mediation, the grandparents must pay for this service. How does military service of a parent impact custody? Military service matters when courts are deciding custody and visitation. A court looks at many different things to decide custody and visitation, like whether a parent knows they will have to move, how the child will adjust after moving, how the child can maintain frequent and meaningful contact with both of their parents, and the ability of the parent to be there and care for the child. Courts in Missouri have made the decision to reduce custody due to the demands of military service. Can an abusive parent get custody or visitation? Yes. Someone who commits domestic violence can have custody or visitation of their child if the court orders it. Under Missouri law, the court prioritizes what is in the best interest of the child. Typically, the court will consider frequent, continuing, and meaningful contact with both parents, the child's mental and physical well-being, patterns of domestic violence, and risk reduction and protection for the child and affected family members. For these reasons, it is important that the child has an individual to advocate for them in these situations.